As the inquirer into the City of Perth, I wish to acknowledge the traditional custodians of the land on which we are conducting this hearing, the Whadjuk people of the Noongar Nation and their elders past, present and future. The inquiry acknowledges and respects their continuing culture and the contribution they make and will continue to make to the life of this city and this region. On the 21st of November 2018, the inquiry into the City of Perth commenced its hearings with a public hearing. At that time, I said that the inquiry would independently discharge its statutory duties thoroughly, fairly and thoughtfully. The inquiry has been rigorous and diligent in undertaking the very important work entrusted to it, and it will continue to discharge its obligations in that way. Since its commencement, the inquiry has been engaged in an extensive program of work. This work has been complex and demanding, but I am pleased to say it has been worthwhile. As a result of its investigatory work, including many private hearings, the inquiry is today in a position to embark on its program of public hearings. In doing so, it will, in an open and inclusive way, address its core terms of reference, namely, whether there has been a failure to provide good government in the City of Perth, the prospect of good government being provided in the future, and the steps which need to be taken to ensure good government in the future. By addressing these very important questions in public, this inquiry will, as it should, continue to meet one of the important underlying reasons for its establishment, namely, to restore the confidence which the public should have in the capital city of this state. Mr. Urquhart.
Thank you, Commissioner. The inquiry into the City of Perth was announced on the 24th of April last year, by the Minister for Local Government under Section 8.16 of the Local Government Act. This week, the inquiry will embark on its first public examination of witnesses. There has, however, been a substantial amount of work undertaken by the inquiry in the past 16 months. There has already been 71 full days of private hearings involving the examination of nearly 100 witnesses. These witnesses have included current and former city councillors and employees, service providers, business owners, ratepayers, and other community representatives and members of the community. As a result of those private hearings, together with the analysis of several million documents and over 100 electronic devices, the inquiry is now in a position to move on to its next stage with the holding of public hearings. Those public hearings will be conducted in 3 blocks over the next 8 weeks. The first block will run for this week and next week. The second block is scheduled to commence on Monday, the 26th of August for 2 weeks, and the final block is expected to commence on Monday, the 16th of September and conclude by the end of the following week. All those public hearings are scheduled to be conducted in this hearing room, which is numbered 2 on level 18 at 111 St George's Terrace here in Perth. The public hearings will not be live streamed on the inquiry's website. However, any introductory remarks by the Commissioner and the opening address by Council assisting at the commencement of each public hearing will be placed on the website as soon as it is practicable to do so. The inquiry's website will also list the names of those witnesses scheduled to be called 1 working day in advance. In addition, the transcript of each day of the public hearings will be downloaded onto the inquiry's website again as soon as is practicable. For the next 2 weeks, the inquiry will be concentrating on the following 5 areas. The first will be whether the criteria for voter eligibility is open to manipulation and whether that has actually occurred with the City of Perth electoral rolls. Unlike state and federal elections, voting in local government elections is not compulsory. Hence, the election turnout is invariably very low. For example, the 2013 City of Perth elections had less than 27% of those eligible to vote actually complete and submit their ballot papers. With a population of less than 30,000, every single vote in a City of Perth election can therefore be crucial. Ordinary elections for councillors take place every 2 years in October. At each of these biennial elections, half the City of Perth councillors, that is, a total number of 4, are elected for terms of 4 years. Ordinary elections for the Lord Mayor also take place in October, but every 4 years rather than 2. Once elected, each councillor, pursuant to the Local Government Act and its regulations, must formally declare that he or she will duly, faithfully, honestly and with integrity fulfil the duties of the office for the people. Although it ought to be trite to say that such a declaration should never be made lightly, it would appear that the subsequent conduct of some councillors meant they did precisely that, or had forgotten what it was they had declared to do. Those who are eligible to vote comprise of residents in the City of Perth and people who, or companies which, own or occupy, usually through a lease, property within the city's boundaries. The elections are conducted by postal vote, and election packages are posted out about 3 weeks before election day to all those on the electoral rolls. Unlike state or federal elections, it is not as simple as one person, one vote. For example, where a company owns or leases property, 2 people may be nominated to vote on behalf of that company. Under the current provisions of the Local Government Act, those 2 nominees do not have to be affiliated with or connected to the company in any shape or form, provided they are on the state electoral roll on a huge discrepancy between councillors regarding the use of these allowances and the amounts that have been claimed. Some councillors have claimed a mere fraction of their reimbursements. In contrast, other councillors have taken a very broad interpretation of what they regard as their entitlement to be reimbursed for clothing, apparel and dry cleaning to cover their attendances at council-related functions. If this is not an abuse of what they're entitled to claim, then at the very least, it would fail the pub test by a considerable margin. Upon the evidence it has heard to date, it is open for the inquiry to make a similar conclusion regarding the use of the council dining room by some elected members. And I must stress, it is only some, not all councillors, that this finding may be made. Notwithstanding the relevant council policy that mandates a limited use of the dining room for elected members to entertain guests at the city's expense, some councillors have flagrantly ignored the limitations that their own policy sets down. Furthermore, precious little was done by the City of staff to stop this abuse. It would seem that as the council policy was honoured more in its breach than in its adherence over a considerable period of time, those city staff responsible for overseeing the correct use of the dining room preferred to maintain the status quo rather than rocking the boat of some well-fed councillors. This, of course, suited those councillors who believed they could use the dining room to entertain up to 10 of their friends and relatives at the one sitting without ever paying a single dollar. The council room has subsequently been closed by the commission appointed to replace the suspended council. That, however, does not prevent the inquiry from conducting its own investigations as to whether there was a misuse by some councillors of their entitlements to use the dining room. A misuse carried out to promote their own self-interest or agendas rather than the promotion of the interests of the city. It was these councillors who got far more than gravy when they boarded the dining room train. The third matter to be looked at is regarding the completion of primary and annual returns by councillors. The Local Government Act requires newly elected councillors to complete what is called a primary return and thereafter an annual return for every year they are on council. What must be included in those returns are all real property interests the councillor has, not only within the boundaries of the council's district, but also any real property interests he or she has in adjoining districts. What must also be declared in a primary return are all income sources that the councillor reasonably expects to receive for the current financial year. And for every annual return thereafter, each source of income received during the return period. It is the rightful expectation of the community that the elected members of their local government carefully and accurately complete these returns. Whether that has been done in all instances by the City of Perth councillors will be another area to be examined by the inquiry. The fourth area that the inquiry will be looking at over the next fortnight is the council's decision-making process regarding a particular application for planning approval. Once elected, a council conducts the business of council by meetings. The council of the City of Perth would usually meet every 4 weeks at an ordinary council meeting to make decisions on the governing of the city. Frequently, when a matter is to be voted on, it has already been before the relevant committee, which usually comprises of 3 councillors. That committee can make a proposal to the council as to whether it should approve or reject the matter that is ultimately to go before it. In a substantial majority of cases, the recommendation made by the administration's officers will be accepted by the council. That is hardly surprising. The officers preparing the recommendations have the necessary training and knowledge to make informed decisions. Usually, the Lord Mayor presides at the ordinary council meetings, which are attended by the other 8 councillors, the Chief Executive Officer of the City, directors of the City, some administration staff, as well as interested members of the media and community. The papers for a meeting are prepared by the City's administration and provided to the council approximately 4 days prior to the meeting. Those papers will include the reports which contain the recommendations for the council to consider and vote on. Matters relating to planning approvals are commonly before the council for it to vote on. Typically, an application for development approval which has complied with all the legislative planning requirements will be approved by the council. Because to reject such an application could inevitably lead to the seeking of a review of the council's decision before the State Administrative Tribunal by the unsuccessful applicant, with all the attendant costs for both parties that are associated with such a legal process. As stated by counsel assisting the inquiry, Ms Lendich, at the inquiry's opening address on the 21st of November of last year, and I quote, "Good government requires openness and accountability. A failure to be open and accountable is not good government. A concept related to good government is good governance. Generally, governance is about the decision-making process and ensuring that there are necessary and appropriate checks and balances in place. It is about legitimate, accountable, and effective ways of obtaining and using public power and resources. Anything less, including the misuse of position and power, is not good governance." End of quote. Whether it be at the federal, state or local level, it is expected that such decision-making must always be transparent and free from improper influence, be it influence that is motivated by self-interest or improper external pressure, or a combination of both those factors. For a local government such as the City of Perth, there is a legislative framework that requires the council to have access to advice and information so that decisions can be made in an informed manner. The Local Government Act and the Local Government Rules of Conduct regulations also make it clear that decisions should be made on the merits of the issue. With that in mind, the inquiry has examined a 2015 decision by the City of Perth Council to refuse the planning approval for a convenience store proposed for the ground floor of the Adagio apartments. At the time, a recently built luxury apartment complex on Terrace Road with sweeping views of the Swan River. The convenience store was to be in that part of the complex that had already been zoned for a commercial tenancy. There is evidence before the inquiry which suggests that the decision-making process for this matter was undermined by a serious and deliberate failure by the council to consider the planning approval on its merits, with the result that the owner of the premises and the store proprietors significantly suffered, not just financially, but emotionally as well. It is open for the inquiry to find that scant regard was paid by the council to a carefully prepared report by officers from the city's Planning and Development Directorate, which had addressed the objections that had been raised by nearby residents. That was done by imposing a number of conditions upon the application. In the opinion of the officers, the implementation of those conditions would make it unlikely that there'd be a significant impact on the amenities for the residents. The report before the council had also stressed that the establishment of the shop was consistent with the intent of the relevant City of Perth town planning scheme and the design policy for Terrace Road. Nevertheless, by a unanimous vote, the council rejected the application. The final area to be examined over the course of the next 2 weeks concerns procurement and contracting. There has been an ever-increasing shift towards the outsourcing of services provided by local governments. The City of Perth is no exception. It engages in a range of procurement activities across a number of services totalling around $50 million per annum. The process of obtaining tenders from competitors for a particular contract should always be the best and fairest way of selecting a supplier to undertake the work in question. However, there is always scope for favouritism, which can arise due to associations and relationships between those providing the tenders and those ultimately making the selection. This risk can be heightened when there is a lack of preventative controls within the local government to ensure such conduct does not occur. During the course of this first block of public hearings, the inquiry will examine the tendering process by the City of Perth for the maintenance of its irrigation bores, pumps and associated works. Though this matter has already been the subject of private hearings. During the course of this public hearing, the inquiry will hear from a City of Perth staff member involved in the process and a manager for governance at the City of Perth. The question to be resolved is whether there were failings in the process that led to one supplier being favoured over others that had also tendered for the contract, and whether those failings were adequately addressed by the City to ensure the same thing did not happen again. Unfortunately, though, there is evidence to suggest this is precisely what happened with the next tender for the same works. I just want to make now some concluding remarks. During the next fortnight, the inquiry will be calling 2 councillors who are presently suspended and 2 who were defeated at the 2017 elections. These councillors will be asked about their conduct with respect to one or more of the subject matters that I have already outlined. Other elected members who were suspended in March of last year are scheduled to appear in the second and third blocks of the public hearings. The remaining witnesses for this block of public hearings will be those who are City of Perth staff members. I wish to conclude this opening address with a warning directed to those witnesses who are to be called over the course of the 6 weeks of these public hearings and who might be inclined not to adhere to the oath or affirmation that they take prior to the commencement of their evidence. Witnesses called at these public hearings should not need to be reminded that when they take an oath or affirmation, they are required to tell the whole truth to all questions asked of them. That obligation remains whether or not a truthful answer reflects poorly on them and whether or not the truthful answer reflects poorly on a person they are or once were aligned with. Untruthful answers that are given to protect inappropriate conduct by the witness or the inappropriate conduct of others arising out of some notion of misguided loyalty are, of course, contemptuous of the oath or affirmation taken to give honest answers to the questions asked. The answers "I don't recall" or "I don't know" in response to an uncomfortable question are also untruthful answers if it is a case of "I don't want to recall" or "I don't want to honestly answer that question." The reason for this warning is that after more than 70 days of evidence at private hearings, the inquiry has had the unfortunate experience of hearing answers from a number of witnesses that lacked veracity, defied logic, and on occasions were an affront to common sense. Regrettably, these answers were not isolated events. I should also add that witnesses to be called over the course of this month and next month would be unwise to assume that the inquiry is not aware of the truthful answers to the questions that are asked of them. The time has well and truly passed when the inquiry was asking questions simply to obtain information that it did not have. Witnesses will also be unwise to assume that an evasive answer which is non-responsive to the question asked will simply be accepted by the inquiry. It will not. The question will not disappear into the ether. It will be repeated and repeated again, if required, until it is answered. Now, Commissioner, a short adjournment may be required before the inquiry continues while some equipment is removed.
Mr. Urquhart, thank you for those very helpful submissions. I will now adjourn the inquiry for a short time before hearing applications and the evidence of the first witness.